Hello everyone and welcome. Today I am honored to host human rights activist and the president of the International and Comparative Law Center, Siranush Sahakyan. Ms. Sahakyan, thank you for joining us today.
Thank you for the invitation.
Ms. Sahakyan, under the November 9, 2020 agreement, both Armenia and Azerbaijan were obliged to return all captives. While Armenia no longer holds Azerbaijani captives, and Pashinyan even released those Azeris that were proven murderers and saboteurs, there was little progress on the Azerbaijani side. Recently, after the pre-signing of peace agreement with Azerbaijan, Pashinyan announced that the issue of captives wasn't included in the document, explaining that raising it would have delayed their return. Is this approach logical, and what does it mean for the future of our POWs?
Let's start from the beginning, from the causes. Indeed, the 2020 trilateral agreement contained an undertaking from both parties to exchange all prisoners for all principle. However, we had witnessed a one-sided violation from the Azerbaijani side. And right now we have 5 confirmed captives, prisoners of war, which were held in 2020 at the time of hostilities, and their release was covered under this agreement. But this shows that international legal obligations, additional political commitments do not restrain the actions of Azerbaijani government, and they always act in breach of international law and political commitments. As of this moment, this issue remains unresolved. However, some releases were happened due to different bargains, including increasing the reputation of certain states, or receiving information from Armenian government, or receiving political support of Armenian government. The vivid example would be the hosting of COP29 event in Azerbaijan, which was possible only with the efforts of Armenian political support. So Armenian political support was traded for the release of a certain number of political prisoners. Based on these developments, we're in a deep belief that a release of prisoners is not a legal issue. It's not a human rights issue. It is purely political issue between Armenia and Azerbaijan, and the rules of this game was mutually accepted by both countries. As this is a political issue, and this is being used as a political tool to exert additional pressure on Armenian government, Azerbaijan keeps the matter within its discretionary powers, and we have seen that, for example, the issue of missing persons, which is two-sided, is included in this pre-signed accord, peace agreement, whatever its name. However, the release of Armenian prisoners is not a condition term for this so-called peace agreement. And this creates dangers. At least society has an expectation that a release should serve as a precondition for completing this peace process. And without release of Armenian prisoners, without resolution of human rights and humanitarian issues, no real peace is achievable, and that would be illusory, fake. So Azerbaijan first should release Armenians as evidence for a potential for building peace with Armenia. However, this is not happening, and if we are modeling a situation when this agreement is concluded, but no release is achieved by that time, then we create more arbitrary situation for our Armenian prisoners, because this agreement has provision for a mutual withdrawal from interstate cases. So Armenia undertakes a legal obligation to withdraw all its cases against Azerbaijan.
Sorry, we'll come to that later. This peace agreement and the opening of so-called Trump route looks more like a business deal benefiting the US and Azerbaijan. However, Trump in a video expresses interest in the release of Christians, while Pashinyan persuaded him not to include it in the document. In this context, can the US play any role in securing the release of our captives?
I wouldn't say that Pashinyan persuaded Trump not to include. I would say that at no price Azerbaijani president was ready to sign any document where the release of Armenian prisoners was present. So I would say this was the rule and condition from Azerbaijani government, which has quite strong powers, negotiating powers. And any such insistence on including provision would have delayed the process, which was not desirable for all parties, including US. So the US maybe pressured the Armenian government to sign this document, irrespective of the fact that release of Armenians was not in this document. However, I think US government can play a crucial role in the release because they were the actor under whose influence peace happened. And release of all Christians across the world is an issue on the agenda of Trump administration. So they do have this moral, legal, political promise to all Christians who are prisoners, political prisoners, prisoners of conscience, to be released due to efforts of US government. And I think 23 Christian Armenians come within this scope of US government promises. And as the peace accord was pre-signed with the efforts of US government, they do have a specific obligation to achieve the release through different trades, transactions, agreements. So in my understanding, President Trump has all potential to offer a deal to Aliyev, with whom they have quite close, even personal, friendly relationship, to release Armenians, increase the role of US government in rebuilding Azerbaijani-Armenia relations, and also give more visibility to this human image of Trump. So I think Aliyev is ready to give credits to Trump and to solve this issue for the Trump and for his reputation and for being supportive for this peace agreement.
Let us talk about the Baku trial itself. Is it conducted in accordance with the law, with the rights of the defendants properly protected, or is it actually a political prosecution where Armenia and Azerbaijan are actually on trial?
We don't have a trial which meets international human rights standards. We do have these sham trials where basically the right of self-determination of Artsakh population is being discussed. Armenians, which do have the status of defendants, accused, are just symbolic. The whole trial is about convicting the right of self-determination for whole Artsakh population. And for us, the outcome is quite clear. Azerbaijan would sentence for long-term imprisonment or would opt for life imprisonment. And here again, we have the symbols. The right of self-determination of Artsakh is being sentenced to long-term imprisonment or life imprisonment, which means no such right can exist in future. Azerbaijan also tries to get confessions from Armenian defendants that Armenian authorities were giving instructions. So there has been established a puppet administration who always received orders from Armenian authorities, and this narrative is necessary for Azerbaijan to prove territorial dispute between Armenia and Azerbaijan. To fully deny the existence of self-determination, Azerbaijan tries to build a scenario where Armenia established this puppet administration, conquered the territories of Azerbaijan and tried to establish its sovereignty over foreign territory through puppet administration. So this is the main aim for those sham trials, but apart from that, they are being used for internal politics, and we would say that those trials also serve as grounds for deepening these anti-Armenian moods and hatred against Armenians in Azerbaijani society. We have seen very harsh, aggressive comments from society members in relation to those trials. So those trials instigate further discrimination against ethnic Armenians in Azerbaijan. If we are considering this human rights component, then those trials do not meet the important requirement of having the cases decided by independent judges. In general, the judiciary in Azerbaijan is very corrupt. This telephone justice is being administered regularly, so all instructions are given by the administration of president. Basically the courts are just implementing the actions which are designed and well planned by the president. Those judges, they are from military courts, they do have this extraordinary composition. Those judges were educated in a society which had this Armenophobic attitude. So even at personal level, those judges are biased towards Armenian because of discrimination based on ethnicity. We have seen that right to defense is fully ignored. All Armenians are represented by state-appointed lawyers. This Public Defenders Institute is wholly failed in Azerbaijan. There are many international reports which raised the issue about lack of independent lawyers in Azerbaijan. Even this debarment mechanism, criminal prosecution, is being used to achieve obedient conduct by lawyers, and human rights defenders, they serve the interest of prosecution, not their clients. So we have just formal, nominal presence of public defenders, but no meaningful legal representation to protect the best interest of Armenians. Just in one case, Ruben Vartanyan case, the family was successful to find a private lawyer who agreed to take an Armenian case. In remaining instances, all lawyers were declining those cases with justification about their security. And also lack of any possibilities to influence the outcome. So they were quite sincere confessions from Azerbaijani lawyers confirming that no meaningful defense of Armenian can happen in Azerbaijan because of this systemic state-supported discrimination against Armenians. So this right to defense is fully illusory, and without right to defense, without right to fair trial by an independent and impartial court, there cannot be any fair trial. But we can list the violations. I would say there is no single right which was observed in relation to Armenians.
Ms. Sahakyan, there were also documented cases of Armenian POWs killed by Azerbaijan. Is there any progress or improvement in addressing these cases?
Our fact-finding activities confirmed many cases where Armenian POWs were executed by Azerbaijani armed forces without trials, without judgment. So these extrajudicial killing practices were widely used. We have scenes of individual executions. We do have scenes of group demonstrative executions with the aim to horrify the whole society. And of course, we have proven cases where captives were killed due to severe beatings and torture. So treatment in closed institutions also resulted in deaths of Armenians. Our organization, with the support of Armenian Legal Center for Human Rights and Justice, took those cases, and we are litigating on behalf of the victims, their families, and we do have already communicated cases. European Court of Human Rights admitted those cases and communicated human rights violation issues to Azerbaijani government. They submitted their observations, and we are having procedural steps. As soon as formal part of the trials are over, we can anticipate court judgments on these cases. The main claim for us is to recognize right to life violations. We always rely on Article 14, which prohibits discrimination in exercise of the rights based on different grounds, including nationality and ethnicity. So we expect acknowledgement of these grave human rights violations and state responsibility. Having human rights court judgments is a key to document grave human rights violations, which also amount to war crimes, and then take additional measures to achieve accountability in criminal sphere as well. I would say that those cases could serve as a solid basis to raise criminal responsibility of perpetrators before different jurisdictions. Could be European states, could be US, but we don't also exclude the legal avenue of International Criminal Court, whose mandate also covers war crimes. But the primary aim is recognition of human rights violations, war crimes, and state responsibility for committed violations.
Ms. Sahakyan, the peace agreement doesn't include any point about the collective right of the people of Artsakh to return to their homeland. Moreover, Pashinyan and his team have said that as long as they are in power, this issue will not be a part of their foreign policy. Does this mean that our government is trying to ignore and abandon the rights of the people of Artsakh, including their property rights? And if so, are there any alternative mechanisms to pursue these rights?
We notice detachment of Armenian government from all Artsakh-related issues, including the right to return. And the Armenian government does not offer any support for Artsakh people, which is quite a strong policy against the concept of democracy, rule of law, human rights, but quite well coordinated with Azerbaijani policies. And even from strategic perspective, this issue is not being raised when Azerbaijani government tries to create a new agenda for international community by bringing this artificial issue of the return of Azerbaijanis to Western Azerbaijan. So on one hand, we have Armenian government who is silent on the right to return of Artsakh people, the right to return of all Armenians who used to live in Baku, Sumgait, Shahumyan, and other regions which appeared under Azerbaijani control before 2020 war. And we have very aggressive state-supported policy when the return of Azerbaijani to Armenia, Western Azerbaijan is being circulated. We don't see any rational policy here, and also very dangerous, because at least raising this issue can counterbalance these Azerbaijani inclinations, which are more of territorial nature rather than return of refugees. We understand that behind any such return, there is a policy to change the demography of Armenian society and have better conditions to implement their territorial demands towards Armenia. So this policy is not human rights driven, but again, it's part of this issue serving the global interests, but not Armenian interest in itself in this region.
Ms. Sahakyan, as you already mentioned, Armenia could have held Azerbaijan accountable for the crimes committed during the war, but instead, under this agreement, we are obliged to withdraw all legal claims from international courts, and we are also obliged not to pursue any legal defense in the future. What consequences might this have?
So first, I would say that the revocation of a right not to bring any legal dispute against Azerbaijan is unconstitutional in itself. So this is an invalid agreement because the right to judicial protection is exclusive. And whenever the sovereign rights of the state or rights of its people are being violated, there should be the right to protect through the legal mechanism. So first, this is an unconstitutional provision, but still in this agreement. And by the way, this is the only provision in the agreement which has time limits, deadlines. So from the moment of entry of the force of this agreement, 1 month period is anticipated for the withdrawal. For example, we have a provision on making joint efforts to reveal the fate of forced disappeared people missing in action. However, no deadline is set to solve this humanitarian issue and somehow mitigate the stress, psychological situation of the families. But when this provision has been envisaged, very short and clear deadlines were set to terminate all types of legal disputes against Azerbaijan. So what this withdrawal means, all human rights violations which were done through military, political ways were raised in these judicial applications. And the only avenue as a last resort for restoration of Armenian rights was the legal avenue. And closing the page of legal avenue would mean that Armenians do not have any mechanism to recognize their human rights violations and restore the situation. So Armenians are forced to accept their victim status and to be adopted to these human rights violations and no prospect for rectifying the situation would remain apart from political. And if this political negotiations works do not prove to be effective, then no mechanism is left. So Armenians would feel themselves in unprotected situation. But from the perspective of the issue of release of prisoners of war, we have more dangerous situation. So their release is not envisaged in agreement. And the legal disputes which requested their release will be withdrawn. So what if the release is not done before withdrawal of interstate cases? What would be the fate of Armenian prisoners in that scenario? The answer is quite straightforward. They will remain solely in the hands of Azerbaijan, and their fate will be dependent solely on the mercy of Azerbaijani government, and without their humanitarian gestures, those people would lose any perspective of release in future, because no legal mechanism would be usable to order their release. So I think this would be the most dangerous situation for Armenian prisoners.
And the last question, I'm expecting a brief answer. Could Armenia revisit these claims again in the future if this government has signed and another government, any future government, can again open these cases or not?
Unfortunately, no. Withdrawal would signal the end of proceedings. And if this procedural right is exercised, there is no possibility of reopening. Of course, the Armenian new government could bring other claims before other international instances, claiming that this agreement was signed under the force, which is prohibited under international law and could lead to invalidity of that agreement. However, I don't know what would be the evidence and how successful would be this procedure. Unless it is established that this agreement was signed under the threat of use of force or through other external measures, there is no possibility to challenge it.
Thank you so much for the interview. Let me remind you that my guest today was human rights activist and the president of the International and Comparative Law Center, Siranush Sahakyan.